Howdy, my name is Brian Foley. I'm a criminal defense attorney in Houston, Texas, and I'm the managing partner at Houston Criminal Defense Attorneys, PLLC. Today we're going to be continuing our lecture series on the Texas Code of Criminal Procedure, and we've got articles 1.04 and 1.05 to discuss today. These are right at the beginning of the code, is the second installation of this lecture series, and these are really I would say they're almost constitutional provisions. They are found in the Texas Constitution, and many of them are in the United States Constitution. So let's get into it. What is Article 1.04? Well, it says this: no citizen of this state shall be deprived of life, liberty, property, privileges, or immunities, or in any manner disenfranchised except by the due course of the law of the land. And that language is modeled after the 14th Amendment, which was passed right after the Civil War. That is the 14th Amendment of the U.S. Constitution. And let's read that one, see how close it is. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without the due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. And so these are normally expanded and contracted by the Supreme Court of the United States. However, the Supreme Court has interpreted that case law related to privileges and immunities and equal protection and due process and things like that. Those are normally the way that the Texas courts will then interpret the same provision. Now, if you notice, there's a difference there. One says equal protection of the law, and the other one, the Texas one, just doesn't have that in there. So there's an entire group of equal protection claims, things like marriage rights and things like that. Those are all found under the Equal Protection Clause of the 14th Amendment. So now let's look at Article 1.05. This, I would say, is the most important part of the Code of Criminal Procedure, but sometimes it feels like it's not that way when you're actually a criminal law practitioner. And the reason is because everybody respects the rights enshrined by 1.05 so much that I've never met a prosecutor, a judge, or an attorney that's ever really questioned the rights that are listed here. But it's not something that really should be taken lightly. Each one is listed out here as a right because it had to be fought for, and because some government at some time had tried to deny citizens the right to these things. So let's look at them. First is the right to a speedy public trial by an impartial jury. And the key part here is speedy trial. So if you're not familiar with that idea, a speedy trial motion is a motion to dismiss the prosecution or a criminal case against you because the prosecutor's office or the district attorney's office has not prosecuted the case in an expeditious manner. They have dragged their feet, they've wasted time, they're delaying due process. And so if you have done something as a defense attorney, you can actually waive this right unknowingly. If you have asked for a continuance when you really didn't need one, just for your convenience instead of in the client's best interest, yeah, that's a no-no. You don't want to do that because you can waive an otherwise ripe, speedy public trial issue. You can waive that by asking for continuance for some frivolous reason, or even a good reason. You really should not be asking for a continuance unless it's super necessary, or if you think that speedy trial is really not going to be an issue, the case is less than a year old, things like that. The next one is the right to a copy of the indictment or formal charging document. And this one, again, seems like a duh. We always get the copy of the indictment or the information in a misdemeanor case. But it didn't used to be the case. It used to be that they hauled people in. We're talking about pre-America here and early America. They would haul you in to jail, and then the judge would just kind of go over with you what happened. There was no formal charging document required, and certainly no copy of it was going to be made for you. The next one is the right not to testify against yourself. And this one is enshrined in the Fifth Amendment right to not have to be a witness against yourself. That's been interpreted by courts since the Miranda versus Arizona opinion to be inclusive of the police having you to read you your rights, where you can be informed by the police or by the state that you don't have to be a witness against yourself, and you don't need to make any statement. If you do, it can and will be used against you, all that stuff. That's found right here in 1.05 in the Fifth Amendment. The next one is the right to an attorney or to act on your own behalf as an attorney, or both. That is obviously very important. They would deny you, even if you could afford an attorney. It used to be that sometimes they wouldn't let you have that attorney come in and speak for you in court. And that is a huge part of our system. It's an adversarial system and absolutely necessary for you to be represented by an attorney. The next one is the right to confrontation through cross-examination of government witnesses. That one is protected by the 6th Amendment of the United States Constitution and Article 1.05. And there was originally a case, the case of Sir Walter Raleigh, where he was convicted in a British court with just affidavits from witnesses. They did not require the witnesses to come talk to him. And in 2004, the right to cross-examination through the 6th Amendment was sort of reinvigorated by a case called Crawford versus Washington. And in that case, they discussed the Sir Walter Raleigh case and how necessary it is to actually have face-to-face confrontation with witnesses that are going to be used by the state against you. Witnesses will sometimes change their story under the crucible of cross-examination, is the way that the court put it. Okay, the next one is the right of compulsory process. This is also known as the right to subpoena witnesses. So it gives you and your attorney the power to force people to come to court in order to help your case or to get information from them, to have them serve as a witness. And then finally, the right to answer to felony charges only after a grand jury indictment. Now, a grand jury, for those of you who don't know, is a group of 12 people who meet in secret with the prosecutor to determine if there's probable cause that an offense has occurred. And if they find that there's probable cause, they issue what's called a true bill. And then your case goes from the grand jury back to the court, where it is possible then to go to a regular jury at a jury trial. But if the grand jury says no, then that's what's called a no bill. And one of the things we do here at Houston Criminal Defense Attorneys is try to present information to the grand jury through the prosecutors, because we are not allowed to appear in front of the grand jury, but we will, from time to time, the prosecutors will allow us to submit information to the grand jury through them. And then we try to convince them to no bill the case. And that's a great way to handle, a felony that's kind of a close call. So that's it. That's 1.04 and 1.05 of the Texas Code of Criminal Procedure. Remember to like and subscribe if you like what you see, and we'll see you next time.